Hey, everybody. Well, big day today. See, I promised you a surprise live if, in fact, we got a guilty verdict before Wednesday. So we'll have our live tomorrow as scheduled, but I thought we'd take a few quick minutes. Hi, Susie Gay. Nice to see you here. I thought we would take a few quick minutes and take a look at the verdict. So we got a verdict today. Now, I've been on Joel Waldman's channel on Surviving the Survivor on and off for the last few days while the trial's been going on. So Joel asked me, hey, what do you think? How long do you think it's going to take to get a verdict? And I said, my prediction is 3 hours of deliberation time. So yesterday it went to the jury and they deliberated for a few minutes, basically. I think they took enough time to elect a foreperson and they went home. So they came back today. They reconvened at 10:30 Pacific time. And lo and behold, they deliberated for 2 hours and 58 minutes before they notified the court that there was a verdict. So how about that? I think I won the pool. Anyway, I wanted to talk a little bit about I wanted to talk a little bit about closing arguments, but I'm just going to play the verdict here really quickly because it doesn't take very long at all. And thank you to Court TV.
I'll ask the clerk to read and record the verdict.
In the Superior Court of the State of Arizona in and for the County of Maricopa, State of Arizona versus Lori Vallow, CR 2021-001704-001, verdict count 1. We, the jury, duly impaneled and sworn in the above entitled action, upon our oaths, do find the defendant, Lori Vallow, as to the crime of count 1, conspiracy to commit first-degree murder occurring on or about July 11, 2019, guilty. Signed, foreperson. Is this your true verdict? So say you one and all.
Yes. On the court's own motion, I'll go ahead and ask the clerk to poll the jury.
Juror number 1, is this your true verdict?
Yes.
Juror number 2, is this your true verdict?
Yes.
Juror number 6, is this your true verdict?
Yes.
Juror number 7, is this your true verdict?
Yes.
Juror number 8, is this your true verdict?
Yes.
Juror number 9, is this your true verdict?
Yes.
Juror number 10, is this your true verdict?
Yes.
Juror number 11, is this your true verdict?
Yes.
Juror number 12, is this your true verdict?
Yes.
Juror number 13, is this your true verdict?
Yes.
Juror number 15, is this your true verdict?
Yes.
Juror number 16, is this your true verdict?
Yes.
Thank you.
All right, I'm going to ask the jury to retire to the.
So that was a very straightforward reading of the verdict. There was only the one count of conspiracy to commit murder in the first degree. Now, there was a bit of an interesting development. Let me get rid of that screen. Oh man, I do not know why my camera is so darn blurry, but I'm thinking I probably need a new camera. Anyway, because it's not focusing. Hello, see that? It's annoying. Anyway, what was interesting about it was before the judge came in and read the verdict, before the jury came in, he asked both the defense and the prosecution about jury instructions for what he called the aggravating factors. So here's what's going on with that. In Arizona, where are we? What state are we in? In Arizona, for a life sentence, they have to be able to, the jury has to find aggravating, certain aggravating circumstances. So the aggravating circumstances were that it was done with an accomplice, that it was done with the use of a dangerous or deadly weapon, and that the victims or the victim's family suffered severe stress and distress. I'm paraphrasing, but so the judge was working on the jury instruction that would have to be given, because the jury would have to go back and deliberate about those aggravating factors. And Lori Vallow asked him, while they were talking about those jury instructions, can I just stipulate to it? And he said, well, you can, but I suggest that you consult with your advisory council. So then they took a bit of a break while they were waiting for the last of the victim's family to come in. The prosecutor stood up and said and victims' families it's mandatory that they be at sentencing if they say they want to be. So they can't go forward without them. So while they were waiting for them to come back, and the prosecutor said, I think they're about 5 to 10 minutes away. While they were waiting for them, they took another break. Then when the judge came back on the bench, we saw Kay come in with Bobby, her younger brother. And then we heard the jury come in. Of course, you don't see them, but we heard them come in. And then you heard the judge read the verdict. So after that was over, he asked the jurors to retire to the jury room while he had a conversation with Lori and the prosecutor about the next phase. When they got there, Lori then did stipulate to the aggravating factors. I thought that was strange because the aggravating, everybody's talking about Lori's hair. The aggravating, those are sock curls, or it may be toilet paper tubes, but I think she curls them around socks. And she has naturally curly hair anyway, so I don't think it takes a lot for her to get those ringlets in her hair. But anyway, I thought it was odd that Lori stipulated, because it meant that after all this time of saying, I didn't do it, I'm not responsible, she then stipulated that the offense was committed with a co-defendant, with a co-conspirator. And she kind of hesitated a bit before she said yes, but she did stipulate to it. Now, what does that do for her if she decides to appeal this case? I think that it causes her some damage on the appellate front, because at this point she has pretty much admitted guilt in a way. I mean, she stipulated that yes, all of this happened with an accomplice. So I'm not sure that was the wisest course of action for her. She did have her advisory council there. When she came into the courtroom the first time, they were not there, but she did have advisory council with her, sitting next to her when she made that stipulation. So, do I think that there was a lot appealable? I don't. I mean, I think that she will complain about speedy trial, and I think that she will, the problem is, what is she going to do? Is she going to allege ineffective assistance of counsel? She was her own lawyer. So, there aren't huge grounds for her to complain, but I do think that she will, I'm sure she will appeal, and I'm sure that she will complain about the speedy trial issues. So I wanted to talk a little bit about the closing. if you watch the closing, I have to say that I thought Trina Kay did a fabulous job on closing. I thought she was concise. And it took an hour and 40 minutes. Closings take what they take because you've got to really go through the evidence, because that is your opportunity to help the jury synthesize all that information into a story. You know, we think in stories. We're programmed from our earliest memories to think about stories, about beginnings and middles and ends, and then what happens. And we learn that in school. We learn to write that way. We learn to read that way. We learn to read it linearly in sentences. And so even though we have this bucket of facts, in order for them to make sense, we have to construct a story. We have to make it fit. And so I thought she did a very masterful job of making the pieces fit into a story that the jurors could understand and feel confident in, that they understood all of the facts and where they all fit in and why they were important. So she did a really good job. She also hammered home all of these people who knew something was amiss with Lori. And she says, Adam knew. Christina knew. Christina is the one who told Lori that if something happened to Charles, she was going to go to the police because she was very concerned about what Lori was saying and about what she heard Alex say, that he wanted to kill Charles. Nancy Jo knew. She told Charles to change his beneficiary and to tell Lori that he'd changed. She didn't tell him to change the beneficiary. He'd already done that. She told him, tell Lori that you've done that because that might make you safer. She talked about the justification defense as excuses, which I thought was a very good way to put it so that the jury understood. And she emphasized over and over and over again the I will be like Nephi and so will you. The text that went from Lori to Alex saying, I will be like Nephi and so will you. Now, for folks who are the uninitiated, folks who are not fluent in LDS doctrine, there is a very famous, very well, I won't say famous, I will say it is a very important story in the Book of Mormon. And that story has to do with Nephi and Laban. Laban is an evil king, and he has some sort of plates that he is keeping from the righteous people. And so Nephi goes to demand that King Laban give him those plates. And Laban refuses. And he goes back, I want to say he goes back a time or two. And finally he goes back and he finds King Laban very drunk, passed out on the floor. And God directs him to kill King Laban to recover these plates. And it is considered a justified, in the minds of LDS doctrine, it's a justified killing for God. So Trina Kay did a really good job of going back to that several times. She did a very good explanation of direct and circumstantial evidence. And she said Lori Vallow was the one who provoked the confrontation. She did a really good job of she did a very good job of laying out the timeline and pointing out that Lori and Alex wanted everyone to believe that this happened really fast. She kept saying, oh, it all happened really fast. And, you know, time plays tricks on you when you're in a highly stressful kind of a situation, no question. But Trina Kay pointed out that the fight between Lori and Charles took 12 minutes. And during that time, Lori had Charles's phone and would not give it back to him. And she was purposefully doing it to provoke him. So I wondered as she was going through that, it was a funny thing because I wondered as she was going through that, Trina Kay was going through her summation, if Lori Vallow didn't count on Tylee coming out with the bat. It was something I'd never thought about before. I've always felt that Tylee was sort of part of the story and that that they had it all worked out ahead of time. But something Trina Kay said, and I can't even remember what it was now, made me wonder if maybe the kink in the plan was they didn't plan on Tylee coming out with her bat. But Trina Kay made a point. She said, killing Charles Vallow was not legally justified, nor was it spiritually justified. There was another thing that I thought was very important, and that was that the jury had a jury instruction. There's a very common jury instruction. It's given in almost every case. And the instruction says, it's on witness credibility. And the instruction says, if a person on one occasion lies and it's proven that they lied, you can presume they will lie about other things. And you can presume that they're not being truthful while they're on the stand. So the jury does have that ability. So then Lori got up and she said, the prosecution 100% has the burden to prove my guilt. Now that's correct, but it's important to remember that that doesn't mean that there can't be reasonable doubt. When she's saying it's 100% their burden, that doesn't mean they have to be 100% certain. 98% is enough. So in burdens of proof, usually what we say, and this is strictly rule of thumb, this is sort of like the way we try and describe it, is if a civil case is decided by a preponderance of the evidence, that means 51% of the evidence tilts one way or the other. There's another legal standard which is used in a few cases, not very often, called clear and convincing. We usually say that's right about 75%. And beyond a reasonable doubt is somewhere between 90% and 100, depending on how you look at it, how you personally assess that. Is 90% convincing, or does it have to be 98% before you're convinced? So what is enough reasonable doubt? So Lori stood up and said they have 100% the burden to prove that I conspired to commit this crime. However, something I don't think Lori really understood, and I'm not really sure how well it was actually communicated to the jury, but when you make an affirmative defense, whether it's you have an alibi or you have self-defense or defense of a third person or some other um, justification defense, the burden shifts because the defendant has the burden to prove that their actions were justified. Now, they don't have to prove they're not guilty. They don't have to prove anything else, but the burden shifts over to the defense to prove that justification piece of it. I didn't think at any point that Lori Vallow put on, well, she didn't put on any evidence, but even in her cross-examination, I didn't think that she really proved that what happened was self-defense. She's still wearing her hair tie wedding ring. I noticed that. Tylee's interview, Alex's interview, both their interviews with the police and the body camera footage with Charles were all kept out as hearsay. Now, I thought the body camera footage, Charles's body camera footage, probably could have come in if they had brought that officer in to testify about being there and meeting Charles and taking the body camera footage. But apparently the prosecution just decided that that was a battle they didn't want to fight. So, and frankly, I think they could have gotten it in. Tylee and Alex's interviews, to the extent that they were helpful to Lori, wouldn't come in because you can't use the testimony, the prior testimony of someone whose death you are responsible for. So that was a bridge too far for this judge. She got frustrated because as she was doing her closing argument, and I had told Joel when I was on with him, we were listening to closings together, I said, the prosecution is going to object because Lori is going to get into objectionable material. And she is going to get into material that either isn't in evidence or however it comes out. She is going to get into objectionable material. The prosecutor is going to object, and that is going to frustrate Lori. And lo and behold, that's exactly what happened. In the end, she was really only able to sort of poke holes in the reasonable doubt by saying things like they didn't test anyone's hands for gunpowder residue. Well, they didn't need to. Alex said he was the one who shot the gun. It was his gun. It was registered to him. There was really no reason to swab the hands of everybody else in the house when Alex Cox clearly said he pulled the trigger. She complained about the fact that they didn't test the bat, that they didn't use luminol on the gun and the bat. And once again, law enforcement said it wasn't necessary. You use luminol when you think something's been cleaned up from blood, but we didn't see any blood. There was one small splash of blood or smear of blood on the kitchen faucet, and that was it. There was no blood on Alex's clothes. There was no blood on his hands, on the gun, nothing. So either he cleaned it up or it was never there to begin with. But repeatedly, the judge told her that she was trying to testify through her closing. And she was kind of trying to get into areas where testimony had not been given before and talk about things that were not in evidence, and the judge shut her down really quickly with the objection of the prosecutor. So she finished by saying, oh, she said that she was praying for Charles and that the whole idea of her, the comparison to Nephi was ridiculous. And she closed by saying that this was an attack on her character, and you may not like me, but there's no evidence that I agreed with my brother to kill Charles. And she ended by saying, don't let them turn my family tragedy into a crime. The prosecutor then got up and said, the execution of Charles Vallow is not a family tragedy. It is a crime. So the jury was out for, I don't know, not very long, 14 minutes, 17 minutes yesterday, and went home, came back today. And so deliberations were a total of 2 hours and 58 minutes. And the jury brought back a unanimous guilty verdict. Lori stipulated to the aggravating factors, and the judge asked when she wanted her sentencing, whether she wanted to do it immediately or whether she wanted to wait until after the Brandon Boudreaux trial. She opted for after the Brandon Boudreaux trial, so we will not know her sentence on this until after Brandon's trial. That trial is set to begin May 30th, and I don't think it will take as long as this one did. I think it will be markedly shorter. I thought about this, and actually when I was on Surviving the Survivor, Tom Evans, who was an alternate juror on Lori's Idaho trial, was on with Joel and I. And we talked about this a bit. And because I wonder remember, there were many things that the jury did not know. They did not know that Lori has already been convicted for murdering her children and Tammy Daybell. They did not know anything about that. So unlike at the Idaho trial, they were able to bring in those prior bad acts, namely Charles's death, to prove motive and plan and all of those things, because it had already happened. But in the case of the children, at the time that Charles Vallow was murdered, none of that had happened yet. So they weren't able to bring that in. So it made me wonder, what is the jury going to think when they get home and they start really digging into this? Because they've spent the better part of a week hearing about this case. They've got to be, and it's weird. So they've got to be thinking, there's got to be more to this story. I'm sure they had questions about where Tylee and JJ were. Why wasn't Tylee there testifying? I'm sure they had many questions. So I'm sure the jurors are going to go home and they're going to start looking into this, and they're going to discover all that information they were not told. And I wonder how that's going to make them feel. I'd love to hear from you all tonight about what you think. I just think we're going to stick to about an hour today, so I'm happy to take some questions and just chat about it. I wonder what the jury is going to think and feel about what they heard and what they didn't hear. And unfortunately, there's not going to be anybody to explain to them why they couldn't hear that information. And the reason they couldn't hear about it is because we do have rules to protect a person's due process. We don't allow prior bad acts to come in if they will be more prejudicial than probative for the case. There's absolutely no question that if that information had come out, if the information that Lori Vallow has already been convicted in the death of her own children, I just think it would have been, they wouldn't have deliberated 3 hours, they would have deliberated 3 minutes. And that's not fair. As much as we all wanted a guilty verdict and justice for Charles, we need to do these the right way. And so we had to know that she was given every opportunity to put on a defense and to have a fair trial. And it wouldn't have been fair if if the judge had allowed the prosecution to tell the jury about what happened in Idaho. So, um, yes, Susie, I see your comment. Thankfully, they didn't acquit. I agree, because I don't know. You're right. I don't know what they would have felt if they had acquitted her on these charges and then watched and then discovered everything else that she had done. I think they would have been pretty horrified. So, in addition to Lori Vallow's verdict today, we also had opening statements in the Karen Reed trial. And I'm going to talk at length about that tomorrow night when we get together for our regular live. If you have questions about Vallow and the Daybell verdict, put them in the chat and we'll chat about those. We're going to chat tomorrow about Reed, about Koberger. We've got a lot to talk about. But I do want to tell you, I think that if you want an education on how to do an opening statement, watch Karen Reed. Alan Jackson did an absolutely masterful job. I mean, award-winning, masterful job of opening statements. It was riveting. And then went on, the first witness on the stand was one of the first responders. And this is the guy who is the only person who ever heard Karen Reed say, "I hit him." And Alan Jackson just surgically impeached his testimony based on the testimony he gave in the last trial, based on, I mean, it was like watching a virtuoso. I'll tell you what it was like, at least for me as a lawyer. My daughter played the cello all the way through middle school and high school, and she and I went to see Yo-Yo Ma. And it was as close to a spiritual experience as I can tell you. He is one of those musicians who is absolutely in the moment. He's not thinking about the note he just played or the note he's going to play. He's only focused on the one note he's producing, and then the next, and then the next. He's a phenomenal musician, but it's more than that. It's a spiritual thing. And I thought about that. I had that same feeling watching Alan Jackson do an opening statement and do that precision impeachment. It was really amazing. So, if you want a lesson in good lawyering, take a look at that. I think this trial is going to give us many surprising moments. Already we're seeing that. So, so we'll be talking about that tomorrow. Thank you, Jen, for posting Yo-Yo Ma. He's a phenomenal cellist. And so what questions do you have for me or comments that you'd like to make about what we saw today? Hello, eat the food, Tina. Do you think Lori stipulated because she didn't want to face Kay, Adam, and Colby? I'm not really sure. Um, eh, because um, they will still have the possibility of reading their impact statements at her sentencing. So this wasn't her sentencing. This was simply her stipulating to the aggravating factors so that her sentence could be worse. Um, and and so I thought it was a little surprising because they were just going to put on the state was going to put on evidence that yes, in fact, a gun was used. Yes, in fact, Charles experienced pain and suffered. It caused anguish to the family, and yes, there was a co-defendant or a co-conspirator. So there really wasn't huge opportunities, and that doesn't preclude Kay and Colby and the whole family from offering their impact statements, and I'm certain they will. So I don't think that changed anything. I'm not really sure why she decided to do it. Maybe she was just tired. Maybe she just had had enough of lawyering. I don't know. Um, but it's a little hard from that camera angle because they were very respectful of her. They usually only showed her from the back. Occasionally, we'd get a side view, a profile view. But what little we did see of her profile, she seemed fairly composed. But it's impossible to say what her face looked like when the jury read the verdict. Now, she's already been here once before, and she was able to maintain her composure pretty stoically in the last verdict reading as well. So, um, I don't know. I don't know why she decided to stipulate. We will have a sentencing, and the victims will have the opportunity to read their impact statements at that point. Yeah. I haven't seen this yet. I was going to go look at it, but I was trying to catch the tail end of the Reed trial. So I haven't seen Colby's reaction yet, and I didn't hear what Jerry had to say. Um, he's a funny guy. He's really a character. I've had some conversations with him, and he's great. So I will go catch that. Um, did a juror say that on his way home last night he heard on the radio that Lori was a convicted murderer in Idaho? If true, is that a problem? Well, what would happen? I don't know because I haven't heard this, but the judge could inquire of that particular juror as long as that juror did not go back to his fellow jurors and say, I heard. I don't think it's a problem. And I think the other thing would be the judge would then ask that juror, did that impact your ability to be fair? And did that influence your decision to vote for guilty? Um, I mean, this day and age, you just can't get away from it. And I get it, that it, media is just ubiquitous. It is out there everywhere, and there's just no way of getting away from it. So, um, oh, hi, I don't recall. So here's what I will say. I will say it's part natural gift and it is part practice and years of experience and thought, um, thinking about it. It is solving puzzles and being somebody who likes a logic puzzle and who likes being able to to figure out how to make those pieces fit. It takes a little bit of a flair. He really has he has a really easy manner. It's clear that he's passionate about things, um, but he also has a tone that really connects with people. When he's talking, he's not droning on, but he's also not um, being so emoting so much that people are like rolling their eyes. He just hits that sweet spot where he's interesting and he's engaging and he just keeps people's attention. It was really, really good. Oh, I'm sorry. This is the nickname for Alan Jackson. He, they say they don't really have a lead attorney, but I think if they do, it's him. He is an attorney from Los Angeles, has been involved in a lot of high profile cases, and is representing Karen Reed. He is admitted to the Massachusetts bar pro hac vice, meaning for this particular case. David Yannetti is actually the local lawyer who has put together the team and his sort of the sponsoring lawyer for the three pro hac vice lawyers. So Alan Jackson is there. He has Sarah Little with him. She's from his office, and also Alessi. His first name just escaped me. But now Alessi tends to be a little bit more passionate. We heard him arguing a motion today after court was over, and it had to do with whether or not they had appropriately turned over text messages from the ARCA witnesses. And he was a little fired up over it. And I don't think it did any good because Judge Bev kind of smacked him down. But yeah, Alan Jackson is an impressive lawyer. And if you want an example of how the best do it, that's it. So I always loved closing arguments. I liked being able to tell the story and put stuff together. But it definitely it takes practice. I guarantee you that Alan Jackson has been working on that opening for weeks, and he has been practicing that opening for weeks. He had it down cold, and doing that, practicing it until it is like muscle memory, until it is ingrained, means that you can be conversational and you can think about other things. You're not thinking about what I'm going to say next. You know what you're going to say next. So then you're more comfortable being able to put it in more maybe conversational tones. So, but I definitely would recommend taking a look at that if you are somebody who loves trials and loves the theater of trials. I don't mean to say that in a negative way. Um, when you are a trial attorney, your primary job is to tell the story in a way that the jury can understand and can process, that a jury can make sense out of. That's your job, is to tell that story in a way that the jury can make sense out of it. So it's theater in the most honorable way to say it. I mean, it is, but it certainly is the best of it. Now, I'm here to tell you there are lawyers who make it's all about the theater. I mean, oh gosh, Jerry Spence with his buckskin coat with the fringe on it, and his I mean, you know, um, it doesn't have to be theatrical, but it does have to be theater. So, hi, Mac. As far as we know, Lori will represent herself in the next trial. Now, she always has the option to ask her standby counsel to step in. And she may, I mean, she may just decide that that was too much, that there was too much to do that she couldn't get done. And there's no argument that she was at a disadvantage being in custody, regardless of whether she was at a disadvantage because she's not a lawyer. She was at a disadvantage because she was in custody and she was having to rely on other people to get things done, like subpoena witnesses and do those things. And sometimes that means things fall through the cracks or they get done wrong, as we saw in her case. So I mean, she could just say, it was harder than it looks, and I don't want to do it again. But we'll have to wait and see. Have to wait and see what she decides, because she's got until the 30th of May, so she's got a little bit of time. Although if she's is not going to represent herself, I hope she lets her standby counsel know right away, because they've got a lot of work to do. Hi, Roz. This is a good question. Brandon was shot after Charles's death. So Charles was shot on July 11th. Brandon, the shot at Brandon was on October 9th. Now, the thing that gets kind of weird about this is that in the timeline, Charles was shot on July 11th. Lori moved to Idaho on August 1st. On September 8th, Tylee disappears. On September 22nd, JJ disappears. On October 9th, Alex takes a shot at Brandon. On October 19th, Tammy dies. And then Alex in December. So, so the conviction for Charles's death could be allowed to come in because it happened before Brandon. So once again, we're in that same situation as we were with him in Idaho, of being able to say Charles's death was only part of a bigger plan, and the plan continued, the conspiracy and the plan continued with trying to murder Brandon. And she's been convicted. The motive was money there. The motive was money here, because she didn't get Charles's $1 million life policy. So yeah, I think there are bits of Charles's, the facts around Charles's death that will come in. So good question. Will she have to explain both storage videos of her and Chad with the tire in the seat to the Jeep coming and going? Well, I don't know whether she'll have to explain it or not, but I'm sure that it will be offered, because those two videos bookend Alex's trip. So for those who might not know, Lori had a storage unit that she had rented in Rexburg, and that storage unit had cameras. So there are cameras that show Lori coming in with Alex and putting stuff in the storage unit. And what it appears that they're doing, the Jeep Wrangler that had been Tylee's has a tire on the back. If that tire is on the back of the Jeep, the back hatch door won't open, the back window, not the door, but the window on the back of the Jeep won't open. So they had to take the tire off. The Jeep Wrangler is a uh, a four-seater, and it has a back seat that comes out. So you can take that back seat out and use that area as cargo space, or if you're, I don't know, um, out mudding it up or whatever. And so they also took the back seat out of that Jeep because that gave Alex space to crouch in there and wait for Brandon with his gun. So, so the first video shows Alex and Lori putting the tire, the spare tire, and what appears to be the back seat in the storage unit. Then a couple of days go by, license plate readers catch the Jeep headed to the Phoenix area. It's in the Phoenix area. While Alex is there, he goes to a pawn shop. I think that's when he goes to the pawn shop. Anyway, that's when they discover that he's in Idaho. And he goes back to Idaho. Once again, license plate readers. And then a day or so later, there is a video of Lori and Chad taking the tire and the back seat back out of the storage unit. So obviously they're going to put it back on the Jeep. So it makes sense from a couple of aspects. One, they changed the appearance of the Jeep thinking, well, maybe people will say, oh, the Jeep I saw didn't have a spare tire on the back. And the other, of course, is to make room for, to make it possible for Alex to be in the back with the window open and ready to shoot. I saw another question, will Tylee and JJ's deaths be allowed in Brandon's case? No, because they happened after again. Once again, that happened afterwards. So it wouldn't have any relevance to planning or motive or any of those things. So it doesn't come in because it would be unduly prejudicial. Again, it's always a balancing act. It's always about saying, is this too prejudicial, or does it have some probative value? Can the jury glean something from this information important that doesn't necessarily have to do with painting Lori as a bad person? So, so no, those won't come in. And I cannot understand they're planning all these crimes, then get married and laugh and dance as if nothing happened. I agree, Carol, but you have to understand that you're dealing with people who are incredibly narcissistic and probably somewhat sociopathic. So I see a comment that I'm going to pull. Hi, I don't recall. I'm an attorney, but I've only been practicing for almost 5 years. I have a lot to learn. You know what? I learned something new every day. That was part of what I loved about practicing law, was the idea that there was something new to learn every day. But the first few years can be really humbling. Really humbling. I count myself really fortunate to have had some really wonderful and generous mentors, and they're out there. Um, they're they're out there because they were mentored. They received the generosity of the profession, and so they're out there to pay it back. I know in my later years, I tried really hard to always put a hand out and try to return what I got, and pay it forward. So look for those mentors. They're out there and they want to help. But, we learn every day as lawyers, whether you've been practicing 5 years or 50 years. So, I mean, I learn something new every day on this channel, and I learn about something in a different jurisdiction that I never heard of before. So, life is about learning and, and being naturally and feeding your natural curiosity. So, I mean, I think of all of there were many, many things I loved about practicing law, but learning something new and facing that challenge of having to figure out the puzzle every day was one of my favorite things. So, um, Lisa Dawn. But Lori is in prison now, so won't or can't that come in without going into detail as to why? No, what the judge said was that it certainly informs sentencing, and it could the jury, if the door were open, the jury could be told that she has been convicted of serious felonies, but the judge was not going to let in those the fact that she was convicted of murdering her own children. So I understand, and I understand that she is now in prison for those offenses, but I still think that it's important. A lot of people asked me, why are we really Roy Clark, thank you for saying the sound is great tonight because I got a new headset and a mic. Because I had some folks saying that my sound wasn't great, that I wasn't that my microphone wasn't that great. My husband was saying it sounded kind of tinny. So thank you for that feedback. I always need to know that because I can't hear it. I can see that my camera's. I thought I had messed around with the settings and that it was better, but it looks pretty bad tonight. So I might be getting a new camera. um, Anyway, I people asked, why are we bothering to have this trial? Because why are, the expense and all of that? Because she's already serving 3 life sentences. And I think there are 2 reasons. One, it's always good to have a belt and suspenders. It's always good to say, well, just in case something goes amiss with Idaho, she gets a new trial. Worst case scenario, those charges get thrown out. We still have her on this other charge. But more important than that is that Charles Vallow was a human being. He was a father and a brother, and there were people in the world who loved him, and his death made a difference for them. His death needed justice. Um, so I know that Kay and Jerry probably both breathed a big sigh of relief that that this next chapter was over. I know they're very fond of Brandon Boudreaux. He was great help to them when the children's remains were found. He was the one who went and identified JJ so that Larry didn't have to. And I know that they have great affection for him, and I'm sure that they are hoping that um, he will get his justice as well. But I'm sure that they are feeling a sense of relief that there's now some justice for Charles as well. So. I don't believe his sons were in the courtroom. No one commented on it. His former wife, Cheryl Wheeler, was in the courtroom for Lori Vallow's trial. I don't recall whether she was there for Chad's or not. She may have been there, but I didn't hear anyone remark that they were there. And of course, we did hear that Colby was there. So, um, by the way, I don't recall. I see there, thank you for your advice. If you ever want to talk lawyer to lawyer, drop me an email and we'll chat. My email's in the show notes. I am always happy to chat about what it's like to practice law. Always happy to encourage. 5 years, I don't think you're a new lawyer, but you always feel like a new lawyer. So feel free at any point to drop me an email and let's chat. So I think that justice was served for Charles, and I think that his sons, all of them, Colby included, can now have some peace and some. I don't think that you ever get closure on grief, but I think that you do have a sense of peace, a sense of all of the sharp edges sort of get carved off and you can live with it. So and I hope that for all of them. But there's no doubt that in this case, they could never get to that point because it was always right in their forefront. There was always something right here for them to think about, whether it was Colby or whether it was Kay and Larry, whether it was, I mean, it was always the next shoe hadn't dropped yet. So I think we're really to the point where they can start to feel like they're headed in the right direction. Like life is going to ease up on them. And that's really important. Yeah. Well, we've been at it about an hour. And you can tell it's spring in Central Oregon, and I'm getting a little gravelly. So let me find out if there are any more questions between and think of questions for tomorrow, because we're going to go live as regularly scheduled tomorrow. But let me know if there are any other questions. Otherwise, I think we will say goodnight. As always, thank you, Jennifer, for always being available to moderate. She is the best moderator in the world, and I appreciate her so much. I want all of you to have a good evening. I hope you all had a great Easter. I know I did. Y'all know by now I love to cook. So we had 8 for Easter brunch, and it was fabulous. Mimosas and Bloody Marys and brunch dishes, and we really had fun. So I hope you had a great Easter, and I will see you all tomorrow night for our regularly scheduled meetup. And we have lots to talk about. We have Koberger and Reed and all kinds of stuff to chat about. So for now, I'm going to say good night.